Hello and welcome. If you've selected this video, it means you're looking to gain a better understanding of intellectual property, or IP, as we'll often refer to it. Here at IP Australia, we're committed to providing information to help you understand the registered IP rights system and how it can protect your unique idea or competitive advantage. Whether you're an entrepreneur with a brilliant business idea, or a researcher on the cusp of a breakthrough, or simply someone curious about the intricacies of intellectual property, we have the resources to help. In this video, you'll hear an introduction from each of the registrable IP rights from subject matter experts. Designed as an entry-level overview, this is part of the self-service products freely available on the IP Australia website that are designed to showcase IP rights and how they apply to you. By the end of this video, you'll have a better understanding of IP, know where to find further information, and the confidence to use this newfound capability. Ready to unlock the power of intellectual property? Let's get started.
Hi, my name is Patrick Johnson and I work in trademark examination at IP Australia, which means I see new trademarks every day. What is a trademark? Often called a brand, a trademark is your identity and is used by customers to differentiate your products or services from those of your competitors. It's not just a brand name or a logo. On this screen, there are 3 examples of registered trademarks. The Nike swoosh is a logo, Cadbury's packaging is an example of how colour can be used, and Tea is an example of how words can be used. It may be your corporate logo, a jingle you use in an advertisement, your business name painted on the side of your truck, or even your packaging. It can be a letter, a number, word, phrase, colour, sound, smell, shape, logo, picture, movement, or aspect of packaging, or any combination of these. A registered trademark provides you with exclusive rights to use, license, and sell the mark. They're a valuable intangible business asset that can grow in value as your business grows. Let's meet children's clothing designers Steph Young and Emily Murray, who started Tutu by You in 2020, introducing the unique Sparkle Band to kids' dress-up costumes.
Our IP strategy for Tutu by You was to protect what we can. We knew we couldn't protect everything, but we knew that there were certain parts of it that we could protect, and they'd just make us feel more secure going to market. Once you're in market, there's no coming back from that. There are so many elements and we just didn't know under which section that we were supposed to be trademarking, whether it was design, whether it was logo. We didn't want to register the wrong thing and for it to bite us down the track.
It takes at least 7 months to register a trademark, as there are waiting and opposition periods built into the legislation. The initial protection lasts for 10 years, but can be renewed indefinitely. For example, the very first trademark registered in Australia is PEPS, a cough and cold tablet. This trademark is still registered and is more than 100 years old. It is important to point out a common misconception here that a trademark is the same thing as a business name, company name, or internet domain name. It's not, and we'll talk more about that later. TM Checker is a new tool that makes it easier for you to check your trademark availability and apply in just a few minutes. It's worthwhile having a play around on TM Checker, as the tool can provide some useful insights on whether your trademark meets requirements and whether a similar trademark is already registered. The tool is free to use, so you can check as many variations of your trademark as you like. The tool cannot give information about the other legal requirements, and so it is not a guarantee that your trademark can be accepted. If you do submit a request through the tool, it will be fully assessed by one of the trademark examiners at IP Australia, and they will let you know the outcome within 5 business days. You may need to seek legal advice for your next steps. Costs for an application through TM Checker or through our TM Head Start service starts at $330. Or there is also an option to apply for your trademark using our standard application online, which starts at $250.
Hi, I'm Samantha Sarles. I'm a senior patent examiner with IP Australia, so I look at any patent applications that come in and decide whether they meet the requirements to get patent protection. A patent provides exclusive rights for a device, substance, method, or a process that is new, inventive, and useful. 3 really well-known examples of patented items are Google Maps, the cochlear implant, and Wi-Fi. A patent will protect a product that's distinguished by the way it works, its composition, or its means of operation. When granted, a patent will give you exclusive commercial rights to your invention. Costs start at several $1000s for full protection, and it can take from a few months to several years to register. It's important to note that you shouldn't share your idea too soon. If you're applying for a patent, it must be new, and it must not be discoverable in any searching conducted as part of the examination process. This includes things like publishing the details on your business website, presentation at a trade show, or even writing about your invention in a Facebook post. Any type of publication before you apply could mean that you are not able to get patent protection for that invention. If you want to discuss your idea with employees or business partners, have them sign a confidentiality agreement or a non-disclosure agreement. This is critical in ensuring your invention is kept commercially confidential and that there's no theft of your idea throughout the prototype development and market testing processes. Here is Aidan, the Chief Technology Officer with Inventia, an Australian company which has patents for its advanced medical research devices.
Having a strong brand is crucial to the success of a product. So we wanted to build something that was a bit more, I guess, flamboyant and a bit more eye-catching and interesting for researchers in a lab. And I think the design is really critical to kind of, I guess, capturing people's imagination. We are developing a very new and innovative technology, and that's really what it's about, is protecting all of the development work and protect the innovation so that we can commercialize and become a successful and sustainable business based in Australia.
Protection of your patent can last for a maximum of 20 years and 25 years for pharmaceuticals. For your standard patent, your first renewal is due 4 years after the filing date. But what can't be patented? No matter how ingenious or unusual they may be, you cannot patent artistic creations, mathematical models, theories, ideas, schemes, or purely mental processes. If you're not sure if your idea is for something patentable, it's worth having a look through the info and examples that we have on our website, or consulting a patent attorney for advice. Particularly in the area of software-related inventions, it can be really tricky to figure out what qualifies and what doesn't. Now, let's take a quick look at the application options for patents. Starting with a provisional application. This is an inexpensive way of signalling your intention to file a full patent application later. Think of it as a placeholder. A provisional application does not provide you with the protection of a full patent, but it does give you a priority date. This is the date your patent will be enforceable from should you go ahead with a standard application. You have 12 months to consider your options before deciding whether to proceed with a complete standard application. A provisional application won't be published unless you decide to go ahead with a standard application. A standard patent application is necessary for full enforceability under the law. It gives you long-term protection and control and is a sellable asset. Whether you apply for a provisional application or a complete standard application, it's very important to include all the information about your invention and how it works. You can only get protection for an invention that you've explained in enough detail for someone else in your field to be able to put it into practice, simply by going off what you've written. It can be really difficult to add in information later on, so it's important to include everything that you might want to protect right from the start. But do be aware that a standard application will end up being published for everyone else to read, even if you end up deciding not to pursue patent protection.
Hi, I'm Laura Harrison, and I'm a Senior Designs Examiner with IP Australia. This means I get to look at new and exciting products every day, and I have the tricky job of determining whether or not a design right meets the requirements for design right protection. One of the best parts of my job is being able to go out in public and see the designs that people have come in and applied for protection for out in the real world. The word design can mean different things to different people, so not everything you design can be protected with a design right. A design right is quite specific. It relates purely to how products look. Essentially, a design right will protect the overall visual appearance of new and distinctive products. The overall visual appearance can be a combination of visual features, including shape, colour, configuration, and pattern. A design right aims to protect the visual appearance of a whole product that has physical and tangible form, is manufactured or handmade, and is produced on a commercial scale. So some examples of products that are protected with a design right can include items of clothing like this Zimmermann dress, gymnasium equipment like this fully trampoline enclosure, and even parts for cars like this Goodyear tyre. Take a look at this video of Ryan Tilley and his business partner Hoi Nguyen, who came up with an innovative idea to allow wheelchair users to access the beach and other difficult terrain.
I think having good IP protection for small businesses and designers is essential in being able to commercialise product and keep it sustainable, to stop the bigger companies and bigger corporations from taking that product, manufacturing it cheaply and undercutting those other small businesses, which often put them out of business.
Applying for a design right is a two-step process in Australia, comprised of registration and certification. Both steps are required to enforce your design right and to stop others from using your design or a very similar design without your permission. Just like patents, you should also keep your design a secret until you have applied. To have the best chance of protecting your design, it should not be publicly disclosed until after you have applied for registration. Even posting a picture to social media can make it difficult to enforce a design right, as then it may no longer be considered new and distinctive. Design right protection has a lifespan of a maximum of 10 years. After this period, you will no longer have exclusive use of your design. Protection initially lasts 5 years from the day that you apply, and then towards the end of this period, you may choose to renew your design for a further 5 years. When applying for a design right, costs start at $250 for registration and $420 for certification. It takes at least 2 months to register and then an additional 4 months to certify.
G'day, I'm Andrew Hallen and I'm the Senior Examiner for Plant Breeders' Rights. I've been working for IP Australia now for 7 years, and we look at the new plant varieties that come through and are protected by PBR. I'm a horticulturalist. I've been in the industry for 30 years, starting off in the nursery industry with ornamentals, and I've worked all over the horticultural industry itself, and this job was a natural progression for me because it keeps me in the industry and a really exciting, interesting place to be. Plant breeders' rights are intellectual property right that grants exclusive commercial rights to plant breeders for their new varieties. It allows them to profit from their work and encourages new plant breeding. Plant breeders' rights affects all sorts of plants, from the plants that we grow in our gardens. We see improved varieties coming through with better disease resistance and drought tolerance, right through to all the food, the plant food that we eat. When you go into a supermarket or into the markets, most of the plant material you see in there is protected by PBR. Not all plant varieties are eligible for plant breeders' rights. To be eligible for a plant breeders' right, it either has to be new or only recently commercially exploited. PBR basically encourages breeders to continue their breeding programs, and the breeding programs are aimed at things like pest and disease resistance, dealing with climate change, and a whole host of other factors that keep feeding the world and providing us good plants to grow. Here's Dr. Michelle Worthington from the University of Adelaide's almond breeding program to talk about the significant role that plant breeders' rights plays for them.
So it's important for new almond varieties to be developed in Australia because the industry really were only relying on 3 main varieties, and if any one of those varieties fell over for some reason like disease or whatever, the industry production would drop dramatically. It's important for new varieties to be developed in Australia because our conditions are different than, say, for instance, Spain, which is a big producer of almonds, and we import a lot of Spanish varieties for the breeding program. You know, our climate's different, our soil's different, and we actually have different markets too than what the Europeans have.
Plant breeders' rights apply to all types of plants, including fungi and algae, and could be relevant to anyone who breeds new varieties of any plant, to be honest. It's important to note that we're not talking about patenting a gene sequence or something as specific as that. With plant breeders' rights, we're actually talking about protecting the whole variety and the name that's associated with it. I'm really passionate about plant breeders' rights and how it can positively impact both plant breeding and also provide food security to the whole world. If you want to find out more about plant breeders' rights, you can look at the IP Australia website, or you can contact the PBR team directly at pbr@ipaustralia.gov.au.
We hope you found that information useful. Want to learn more? IP Australia offers a range of tools, resources and services with practical guidance to help you navigate and engage with the IP system. For the latest news, you can follow IP Australia on social media. We're on Facebook, Instagram and LinkedIn. If you'd like to provide feedback on this video, please email outreach@ipaustralia.gov.au.